By Friday, it appeared that there was consensus among the African National Congress National Executive Committee that the time has come for a government of national unity. This comes after the ANC registered its worst ever performance in the 3 decades history of democratic South Africa at the May 29 polls. The neighboring country is one of the 6 nations in Southern Africa and one of the 64th countries heading to the polls this year. Due to the inextricable ties between Namibia and South Africa, and the fact that Namibia's presidential and National Assembly election are slated for November the 27th this year, the unfolding scenarios south of the Orange River has a particular bearing on the land of the brave. So in this historic episode of the Wheels of Justice, we juxtapose the Namibian electoral system against that of its South African counterpart. Greetings, I go by the name Daniel Nadunya, and I will be your host for this evening's discussion. So fasten your seatbelts and grab your warm beverage of your choice, because we'll be back in a jiffy. Welcome back. This is your weekly dose of the Wheels of Justice, and joining us for this evening's proceedings, one of our usual suspects, Mr. Henry Shimtwikeni, a legal practitioner at HS Law. And all the way from the neighboring South Africa is Advocate Mark Oppenheimer, a member of the Johannesburg Bar. Leonard Friends, welcome to the Wheels of Justice, and thank you for making time.
Thank you for having us.
Great. Advocate, the custom on this platform is that we accord at least an opportunity for those joining for the first time to make their maiden statement or dispose of any preliminary points that should be actually dealt with from the onset. If there is any, it's now an opportunity for you to raise any point in limine.
Well, thank you, my learned friend. So this is a historic outcome for South Africa. As you mentioned, the ANC has been in power with quite an ample majority for the last 30 years. And so to see them reduced to 40% in the election has been quite a startling occasion, and one which I think in some senses has taken the ANC and the country by surprise. But those that were paying attention to the polls would have noticed that the results came out almost exactly within the margin of error predicted by a variety of pollsters. And so the question now really is, what happens next? Yes. And Cyril Ramaphosa, the president of the ANC, has made an announcement inviting a number of parties, but not all parties, to a government of national unity.
Right.
And so this may remind people of what happened in 1994. In which a number of parties were invited to join the Government of National Unity, and the National Party and the Inkatha Freedom Party initially joined that government and governed together for a number of years before the National Party removed itself from that Government of National Unity.
Yes.
Now, what's of course interesting is that not everybody has taken up that invitation. The Economic Freedom Fighters and Umkhonto we Sizwe, Jacob Zuma's party, have said no thank you if you're going to include the Democratic Alliance.
Right. Mr. Shimtwikeni, I mean, we've just heard, I think Advocate Oppenheimer just set the tone for our discussion tonight, but let's also accord you an opportunity to basically raise any point that you would want us to deal with.
Well, look, I think, look, I'm not raising an introductory point of being on the show.
Yes.
I just think that listening to Advocate Oppenheimer, I think the ANC to call what they want to form a government of national unity is very mischievous.
Right.
It's mischievous because unlike in 1993-94, there was a particular framework for that, which determined how it's going to happen. So, in essence, it's semantics. It's nothing more than a coalition. in a coalition which they're trying to portray as very inclusive. But at the end of the day, it's no difference from any coalition any coalition that is formed it's common in especially European countries. So to call it a government of national unity, I call it mischievous.
Right.
It's a very mischievous attempt.
Well, we'll get back to that. But
yes.
From the onset, maybe let's lay the foundation for this evening's discourse by basically, in broad strokes, unpacking the overarching legislative framework that governs elections, both in South Africa and in Namibia. Perhaps let's start with you, Advocate. Perhaps let's kindly unpack the legislative framework that governs elections in South Africa, and then we'll bring it back to Namibia and then see the similarities and differences.
Yes, well, our foundational document is the 1996 South African Constitution, which sets out how our elections are to occur, in addition to the Electoral Act, which was recently amended to allow for independent candidates to take part. So the way that our elections work is that we must have proportional representation, so different from a first past the post system, and it means that there is a partial cutoff in order to get a seat in Parliament, which is that one must have 0.25% of the vote, roughly, to get one seat. And then once the South African electorate has voted, the members of Parliament will then be sworn in, and then they will have an election for president. So this is why the deal-making is important, because, as we mentioned before, the African National Congress, who could always rely on their own members to vote them in with no reliance on anyone else, can't do that. And so they will need some kind of agreement with other parties to get the 50 plus 1. In other words, they need at least 201 people to vote, assuming that everybody turned up to Parliament. There's some ambiguity because, of course, some controversies have threatened not to take up their seats. There's a quorum requirement, so you must have a certain number of MPs available to vote, and then really it's 50% plus 1 of those that attend, provided that you meet the quorum requirement. Now, there are a couple of ways in which the government of national unity could play out. One, it depends on which parties actually become part of this, and it might just look like a simple coalition, in which sense it's correct to say that it's mischievous language. It could be a coalition that takes part in the sense that you have true co-governance. So you could have cabinet posts or a deputy president that's handed out to different parties, or you could have what's called a supply and command agreement, where the parties that form part of it will say, we'll agree to support Cyril Ramaphosa for president, and we'll agree to support your annual budgets and nothing else. We won't take up positions in the executive. They might take positions up in other watchdog roles, head of parliamentary committees, but that would then allow them to play the role of opposition, because they wouldn't actually be in the government, and they would always have a loaded gun at the ANC's head saying, if you do things that we disapprove of, well, then we won't support your budgets, or we might support a motion of no confidence. And if 2/3 of Parliament call for the president to be removed, then he must be removed. And so you could sort of trigger a crisis if that happened.
Yes. Mr. Shimchuke, let's juxtapose the South African legislative to that of ours.
Look, I think, like Advocate indicates,
yes,
both of our countries are primarily premised on the Constitution. The only fundamental difference is in terms of the election or selection of the head of state.
Yes.
Yes. So in our context, we have the parliamentary, we have the votes for the parliamentary seats, but our president is elected first past the post, meaning that they are nominated by the particular party, but the head of state is elected as a head of state individually. It's more first past the post. It's not elected like, look, to make it simple for Namibians, let me just explain to say that in South Africa, the president is elected the same way that the mayor of Windhoek is elected. In that at the first, at the seating, I think in South Africa is 90 days or so after the maximum after parliament sits, they must elect a head of state. Whereas in Namibia, when we go to the ballot, we have the party, and the president. That's why we have independent candidates who stand for the presidential position.
Yes.
Yeah, so that's the most important, in fact, that's the fundamental difference between our systems. South Africa's system is very much similar to the election of most prime ministers in European countries. But at the same time, I think that what we're seeing now in South Africa, and that's why I again say it's very mischievous of the ANC to call it a government of national unity, is that their constitution foresaw a situation like this, and there's absolutely no reason to treat it like it's a crisis. Forming coalition governments in terms of democratic countries which have founding documents like the South African Constitution, this is an ordinary process which should happen, whereby the particular parties with a particular number of seats need to determine the executive. Because remember that what we're seeing playing out here, which happens here, which is a bit different, is that you've got three arms of government. You've got the legislature, you've got the executive. Yeah? So what we're seeing now is basically the legislature is determined. The people voted. So what they're doing is to say that how are we going to agree in terms of how we're going to determine the executive arm of government? I then say that you can't call it a government of national unity because there was a particular framework. Look, in 1993, at the time, Mandela's cabinet had 27 ministers and 13 deputy ministers, which served a particular post-apartheid purpose. So for the ANC to try to I think, trigger a crisis out of an ordinary process, ordinary democratic process, I don't think is necessary. My view is that the interpretations should just do what they have to do. And it's nothing more than a coalition that needs to be formed to enable the other arm of government to function, which is the executive, because that's actually what it means. Coalition means determining how it is that the executive is going to be composed, from who, by who, and how.
Yes.
Yes.
Perhaps, Advocate, talk to us about what the law of South Africa say insofar as marginal victories and issues of coalition governments are concerned.
Well, Henry's right to say that things were different in 1993 because the interim constitution made specific mention of this notion of a government of national unity.
Yes.
And any party that exceeded 10% in parliament would then have the opportunity to join that government of national unity. The final constitution makes no mention of it. So there's a sense in which referring to a government of national unity is more of a branding exercise than one that refers to any legal state or legal obligation. There are a couple of ways of trying to cash out why the term was used for strategic reasons. So because the different there are four parties really that have gotten significant amounts of power, and then there's about another six that have gotten smaller amounts of power in terms of representation from the voters. And the difficulty is that the Democratic Alliance is largely a centrist party or classical liberal party. The ANC are, let's say, a left-leaning or socialist party. And then you have MK, which views itself as an anti-constitutionalist party. It says that if it were in power, it would remove the South African constitution. And then the Economic Freedom Fighters see themselves as a radical Marxist party and have called for the constitution to be amended to remove private property rights. So it's quite hard to include all of those voices in a true government of national unity. So what you have is a situation where it's not possible to include them all because they've all said they won't work with each other. But you might think that it's also very hard for the ANC to say that it's picking one camp over the other because it itself is a house divided. It's trying to structure itself as a broad church. Some people are very sympathetic to those breakaways from the ANC being MK and the EFF. Others are more sympathetic to the market-friendly Democratic Alliance. Others are very hostile to the Democratic Alliance. So it's possible that either Cyril Ramaphosa is unable to make a decision and just said everybody's invited, or that there's some 4D chess going on to say, well, I know that if I invite everybody, I know that not all of them will arrive. And for the sake of South Africa's future, he may hope that the Democratic Alliance and the Inkatha Freedom Party are the ones that actually join. I haven't said that we simultaneously had a provincial election in which the ANC lost control over KZN in terms of numbers. But Umkhonto we Sizwe, which got the highest amount of votes, didn't get a majority there either. So this suddenly becomes very important because if the ANC does a deal with IFP and the DA, and the NFP being a party that got one seat, then they would be able to ensure that MK doesn't have control of KwaZulu-Natal. As I mentioned before, it doesn't necessarily have to be a formal coalition. Again, the parties are able to reach an agreement. There's no law that prohibits them from structuring that in any way they want. So in that confidence and supply arrangement that I alluded to earlier, it's entirely possible to give some kind of executive control at a provincial level to a party like the IFP in KZN without necessarily including them in cabinet at the national level. So there are going to be some sort of devil in the details things that come out in the days to come.
Yes.
I will say something else that's quite interesting. So we changed our law in that we allowed for independent candidates to run. And it's had a dramatic impact, but not the one anyone expected. So no independent candidate is going to be sitting in Parliament. No one got anywhere near close. But what we did do is we changed our balloting system. So as I mentioned, we have 400 seats in the National Assembly. And you would have a party list system where every party would have a list of its members in a particular order of who would go. But now, because we have 3 ballots, so one national, one provincial, and one regional, and the regional really is people who are going to go to Parliament. What the DA and the EFF did was they realized that if you want people on your list to go through to Parliament, you have to have duplication on your list, on the regional list. So you rotate it. But the ANC either didn't realize this or deliberately decided not to have duplication,
right.
Which means that 173 members of Parliament who are currently sitting in Parliament from the African National Congress will not be going back out of 257. So 69% of people who have a job in Parliament will no longer have a job, which means you have a huge turnover, which could also mean that we have serious anarchy when it comes to picking the president. So one of the things that I didn't mention was that we actually have a runoff system when it comes to voting for the president. So when Parliament votes, you can nominate more than one person. And the process is such that the person who receives the fewest votes drops off the list, and then you immediately go to a second round of voting without room for debate. So it's possible that in an initial move to try and punish Cyril Ramaphosa, that no one votes for him. But maybe people have the intention of voting for him later. But if he's removed from the list, he can't be re-added. And so we could very well have a surprise president.
So I was just curious to hear what then happens in the event that consensus is not reached.
Yeah, so the rule is that in order to be elected president, you must have a majority of those that vote. So you will run the runoffs until you reach that majority. And so a consensus will necessarily be reached. The Constitution does make mention of a tie, and there's a tiebreaker mechanism. But it might very well be that you could have a lot of people that say don't take up their seats like MK, but there's still quorum. And then you'll have rounds and rounds of voting until someone is elected. If at the end of that there is an unhappiness, then you would have to take a move to remove that particular president.
Yes.
But they would be elected president.
Yes. Mr. Shimtugeni, how would that play out in the Namibian context?
In terms of the removal of a president?
In terms of a marginal victory and maybe a coalition needs to...
Look, I think, again, I always emphasize that we must, when we speak from a very strict perspective, when we speak about coalitions, hypothetically, like advocate is indicating, in the absence of the discussions, all that needs to happen is that Parliament in South Africa is convened and they elect the president. In our Namibian context, what we've seen in terms of marginal, I think perhaps the most similar.
And that would play out on the National Assembly, not necessarily on the presidential.
Look, our national elections, our parliamentary elections, for the parliamentarians, for the seats, for the proportional representation, they won't
Yes.
have an impact on the president.
Yes.
So it's very different, and that's what we need to realize.
Yes.
It's extremely different because our parliament is elected, the parliamentarians are there based on their parties, proportional representation. The president is elected directly. The worst that you can see is if somebody doesn't achieve the 50+1
for presidential,
yes. Then there will be a rerun where the other ones will be cancelled. It will only be the 2. You get it? That's what maybe we can see in November. If no one attains
50+1.
Yes, 50+1. Then you'll have a rerun with just those particular 2 individuals. That's perhaps the most similarity that we'll have. Because
the 2 individuals are ones with the highest votes.
Yes, you get it. That's perhaps the closest that we can come to that. But ours is and it's important for us to realize what Advocate is saying, that our systems are quite different. Our president is elected. In fact, we have the possibility in November. I'm not a political scientist, but the possibility exists that you can have a particular president from a particular party, but their party doesn't necessarily have majority in parliament.
Right.
You get it? Or their party did very dismally in parliament. We had an independent candidate at a particular time who ran for president but didn't have a party.
Yes.
In parliament.
Yes.
Imagine how the possibility if that particular individual was elected as president, if he had won. It was Dr. Itula at the time. He got, I think, 37% or 36% of the national vote, but his party didn't run for parliament. But he was running for president. But he was running for president of the country. So then to select his executive, he's going to have to select it from somewhere there. Unless, of course, we also have the 10 that he can appoint directly as the president, then perhaps he can select the executive from there. So our systems are very different, and that's important for us to understand. Because a lot of people are comparing our elections to theirs, but our election of president versus the South African system is very different.
Yes.
Our president is elected directly. You can run for president without having a party, without even running for parliament. In fact, there's a case which was filed recently by the same Dr. Itula, and his contention, I don't think it has been decided yet, is to say that if you are running directly for president, you shouldn't be on the parliamentary list.
Yes.
I don't know if you've heard about that. That's what he's saying. It's not been determined, but it's something that is interesting to note, and it's nice for separation purposes. In South Africa too, I do believe once you become the president, Advocate can just assist me.
Yes.
I do believe that you then are no longer a member of parliament.
You're no
longer a member of parliament. So that particular case's contention, I don't know that.
But isn't it the same in Namibia? Once you are then elected as a president, you are not a member of parliament. However, what plays out in Namibia is that members of the opposition parties
they are in the list,
who were also contesting for president
are also in the list. So that's exactly Dr. Itula's case, to say that, look, if you are running directly for president, you shouldn't be in this list at all. Look, you get it. So it's just to indicate the difference, you get it. But it's interesting. I hope it plays out very well. And that particular case is not dismissed on technicalities, and the substance is determined in terms of that.
Yes. Yeah. Advocate, South Africa's Constitutional Court recently found that former President Jacob Zuma may not be elected to serve in the National Assembly due to his conviction on contempt of court and prison term exceeding 1 year. Please help us understand this ruling.
Yeah, so the first thing that's worth saying is that the Constitutional Court overturned the Electoral Court. So the Electoral Court had found that former President Zuma was entitled to be sworn as a member of Parliament. So our Constitution has a rule which says that if you have been convicted of a sentence of more than 12 months and it is not on appeal, then you may not be sworn as a member of Parliament until 5 years has elapsed. So there were a couple of different reasons why the Electoral Court thought that this didn't apply to Jacob Zuma. So the one was to say that because his sentence was from the Constitutional Court and was for contempt of court, there was no possibility of an appeal. So the view was that because it was unappealable, because there is no further court beyond the Constitutional Court, that meant that the provision couldn't be invoked, because the provision makes reference to an appeal. The other argument that was made was that there was a remittance of sentence. So he was not pardoned by Cyril Ramaphosa. There was a general remittance for prisoners in a certain category of non-violent offences that happened to take effect, I think, about 2 hours after former President Zuma walked into prison. And so he was then released along with, I think, over 1,000 other people. So the electoral court then held that he was entitled to take his oath. The constitutional court then said no. First of all, the fact that it was not appealable is neither here nor there. It's only if the matter was on appeal. There was finality because the constitutional court had determined this, and a remittance doesn't change the fact that you were actually sentenced to a term more than 12 months. It doesn't expunge it. And so they took, I would say, a common sense, ordinary interpretation of what the language meant. There was, I will say, some significant outcry when the electoral court produced this judgment, and I think some would have thought that it was done purely for political purposes. Obviously, there's a strong view in South Africa that President Zuma was behind the July riots in 2021, that there would be the possibility of electoral violence. At the end of our current elections, former President Zuma made claims that the election was stolen from him, that actually he should have gotten 2/3 of the vote, and that if the IC was going to release the election results, that there would be trouble and they should stop doing this, and so a kind of implication that there would be violence. And thankfully there hasn't been any violence. But it is an important reminder that the job of the court really is to apply the law as it sees it, not to make political decisions for expedient purposes.
No, although it remains unclear whether he would actually have run for parliament, it is not clear, but it is also understood that should he have been allowed to basically run, and should he have made it, he would have forfeited his benefits as former president, including security and other benefits. Please contextualize this for us.
It's actually an issue that had arisen before for former President Kgalema Motlanthe. So he was president for a short period of time after Thabo Mbeki resigned, and then he became deputy president. And so the question was, can he continue to get his presidential benefits while also earning the salary of deputy president? Yes. And he was Jacob Zuma's deputy president, so Jacob Zuma said, well, we should have some kind of ruling on this, and the ruling was that he would have a choice. And what Kgalema Motlanthe then did was he said, well, the pension benefit is greater than my salary, so I'll take the pension benefit. So Jacob Zuma then wouldn't have been forced to forfeit the security benefits and the presidential salary, which I think in 2018 was roughly 3 million rand. And the parliamentary salaries are roughly 1 million rand. So he could just renounce the parliamentary salary and then keep taking the presidential pension.
Yes, Advocate. Let's just make it clear. Does it mean that the current or the status quo is that he then keeps all his benefit as a former head of state at the moment?
Yes. It does. And so even though he was convicted of contempt of court by the Constitutional Court, that doesn't mean that he forfeits his current salary. So he continues to obtain all the benefits of any other former president.
Right. Thank you so much. Mr. Shimtukeni, is our law vocal insofar as the benefits of former heads of state should, in fact, maybe let's talk about whether our former heads of state can still stand to be re-elected.
Look, we've got a limitation of 2 terms. Now, in terms of we've got a limitation of 2 terms, similarly to South Africa. But in terms of the particular benefits.
Yes.
And again, I want to speak from a comparative perspective.
Yes.
Ours is very different, and in fact, I don't think. When it comes to the benefits, I think South Africa's comparison must compare a little bit more again, let's say to Britain.
Yes.
Because theirs is very similar to electing a prime minister in Britain. You get it? The only difference is that the prime minister never loses their seat in parliament. You get it? If they are no longer prime minister, they just go back and sit in. They just take their seat in parliament. So when it comes to those particular benefits, I like the example you've made of Kgalema, because I did my research around that a few years ago. A few months ago. I too wasn't too sure, but when he contextualizes like that, it seems like it's not really a legal interpretation, it's a very administrative. To say that Kgalema then chose and says, no, I am not going to take the deputy president's salary, I'll take the other one. I don't know where it's dictated in terms of law. I didn't hear it from advocate. It sounds very much administrative.
Right.
Yeah, it sounds very much administrative.
Is it administrative, advocate? Or
So
is
it
it a
comes
matter
from
of
the
law?
presidential handbook.
It's in there? Yeah.
It's in the presidential handbook, which I suppose we might think of as being a regulation as opposed to a statute. So I think describing it as administrative is a fair account.
Right.
Yeah.
So then what we are saying is that in our case, that scenario may likely not take place.
It's quite unlikely. It's very unlikely.
Right.
In fact, you must understand that also, look, again, coming back to how advocate opened in the beginning, South Africa is at a juncture which is very odd and new. Odd and new in that you had the possibility of a former head of state who served almost a full 2 terms, should it not been for the Constitutional Court, coming back to Parliament. Odd and new in that perhaps within the British context is normal, in that once you remove this Prime Minister, you just sit. But in South Africa, had it not been for the Constitutional Court, it would have been a very odd and new situation to deal with.
Yeah.
Odd and new situation to deal with. But the thing is that the framework semi-foresaw it, and then the in-betweens, you have to patch it. But it would have been a very odd, new, interesting scenario had the Constitutional Court not made the decision that they did.
Yes.
Yeah. Had they allowed him to be in the list. Advocate, I think it would have been very interesting. What do you think, Advocate? Former head of state sitting in Parliament, it would have been quite interesting. I was, Advocate, what's
Well, as you say, it's what happens in the UK quite frequently.
Yes.
So you had Theresa May becoming a backbencher after being Prime Minister. So it may have been an interesting situation. I suppose we haven't really had that in South Africa. We have had President de Klerk become Deputy President de Klerk. So there is a sense in which people have played different roles. But he didn't take up a seat in Parliament afterwards.
But President Zuma is only barred from running for Parliament for 5 years. Can this mean that he could run during the next election then?
Yes, that would be a possibility. I think he would be 87, but there would be no legal barrier to him doing so.
Yes.
What is, of course, interesting is that there has been some litigation over who the leader is of MK, with Jabulani Khumalo having been kicked out by Jacob Zuma, and Mr. Khumalo claiming that this was done maliciously and that there's no legal basis for having removed him, and he remains number 1 on MK's parliamentary lists, and so may very well be sworn into Parliament.
Right. Thank you so much. You're watching The Wheels of Justice. On the agenda tonight is the Namibian versus the South African electoral systems, a comparative analysis. When we return, our telephone lines will be open for any questions of clarity or contributions of a constructive, crisp, and clear nature. Don't move an inch. Welcome back. Our telephone lines are now open for any questions or comments as far as Namibia and South Africa's respective electoral systems and the law are concerned. Our number here in the studio is 291-3339. That is 291-339. And if you are calling outside the capital, the area code in Windhoek is 061. The lines are now open. Mr. Shimtwikeni, would this apply to Namibian heads of state convicted and sentenced to imprisonment for more than 12 months as well?
Yes, it applies. Our constitution has the same principle. I think the only difference in our constitution, to the best of my recollection, I think it says, after 10 years, then that particular conviction no longer applies. So the provisions read very similar. Ours is just a bit longer. I think it says after a 10-year period after the conviction,
Yes.
then you can then serve. I just think it's quite, look, when we see, it has never played out here in Namibia, so it applies, the same principle applies. Sentenced without option of a fine for 12 months or more. Zuma, I think, was sentenced for 15. You also can't serve it, similar principle. Yeah, I think it's just, when you see the litigation around it and you see in terms of how advocate was explaining, my interpretation is that it's just interesting because, remember, in my interpretation of it, firstly, his conviction was is not your traditional conviction where you are served with a charge, where you are given a charge sheet and then you appear and then you are then convicted and you go through a trial. That's why there's different decisions around it. Obviously, the Constitutional Court being the supreme one. It's a semi-post-civil criminal charge. It's contempt.
Yes.
You get it. It's not your normal crime that we see.
Yes.
Hence, we understandably saw discussion around it and different discussions around it and different decisions around it. Constitutional Court being the supreme one. I just think that my view, looking at the Constitutional Court, the same court, mind you, that convicted him of the same.
Yes.
South African judicial system is a bit different from ours in that they are a little bit more inquisitorial than ours, in that they go inquisitorial, meaning that how do you say it? They go a little bit more into what is going on,
yes,
and then the bench or the forum, the decision maker, makes its own decision.
Based on
they're a bit more other circumstances they consider. That's a bit different from us. Even if you study very carefully our judgment in terms of the.
Thank you. You'll just have to hold your thought there. Let's hear from Aune from Okahao. Good evening. Good evening. Miss Aune, good evening. All right, let's continue.
Yeah, so that's the bit of the difference. But I do think that the South African system really, we need to move a little bit slightly. Our system needs to be a bit more inquisitorial too, to be able to make decisions other than those that are asked for, to be able to analyze what is going on, make particular. Where our judiciary, I think our judiciary is brilliant, it's independent, similar to South Africa's, but obviously we must borrow from those kind of interventions where our systems are still very much based on what is presented, and the courts don't really go beyond that.
They cannot decide beyond what is presented,
beyond
what is brought before them.
Yes, it's very interesting. It's very interesting. Obviously, I've seen a lot of critiques in South Africa against it, particularly from the political areas, because there's a risk. When you're a bit inquisitorial, you have a risk of being accused of being semi-political. But then you make correct decisions. So I don't know. Our system has not been tested like that. You get it. We came from the electoral court. He was supposed to go to Parliament, Constitutional Court, then rules against it based on their own. You understand? Obviously, we don't go into the judgment now. Advocate mentioned it, but it's very interesting. Our system has not been tested like that yet. But the provision of 12 months is here too.
Yes. Advocate, I think at this juncture, it seems more appropriate to have a look at what the two countries' supreme laws stipulate insofar as presidential immunity for both sitting and former heads of states is concerned. Maybe let's start with what the South African law provides.
Yes, so we have a section in our constitution for parliamentary privilege. So they're immune from, let's say, the kinds of things that they say in Parliament. They can't be held civilly liable for defamation, for example. And it provides for national legislation to be enacted for other kinds of immunities. But in practice, we don't have it. So there is no criminal immunity for a sitting president or a former president, which is why it was possible for Jacob Zuma to be convicted. He also stands accused for a long-standing matter relating to the arms deal. I think that case has been running for almost 20 years now. And it's interesting if you think about America as an example. Donald Trump has claimed that he's got presidential immunity, but it's actually quite an ambiguous situation in American law. Their constitution doesn't provide for it explicitly either. But in practice, their State Department has behaved as if presidents have immunity. One of the things that was interesting about our constitution was really this idea of everyone being equal before the law. And so in a case called SAFU, President Mandela was subpoenaed to testify as a witness. And there was a question as to whether this was appropriate or not. And the view was that he might be the first citizen, but he's the first among equals. And the court said that there is no outright ban on requiring a president to testify in a trial, just that it should be done only under exceptional circumstances, because obviously, presidents have other things that they could be doing.
Advocate, just hold your thought right there. Let's hear from Kreshi calling from Swakopmund. Good evening.
Evening, how are you, sir?
Good, thank you. Your contribution or question, briefly.
Yes, it's just a question in the context of Mr. Zuma. Like, as it states that he still enjoys the benefits of the former president. And then he say it happens that he would have gone to parliament and become a member of parliament. What happens with his benefits? Do they revoke the other benefits of the former presidency, or does he enjoy the double benefits of him being of double benefits of former president's benefits and the member of parliament benefits?
That is in the event he contests for presidential
member of parliament.
Member of parliament. That yes. Is in the next 5 years, because yes. It's not going to happen now.
So, say for example, if it has happened that he was not having those criminal issues and he went to parliament now. So, was it that he was going to get both benefits of being a former president and the member of parliament, or were they going to withdraw one of the benefits?
Thank you so much, sir, for your question.
Thank you.
Advocate Oppenheimer, I think you dealt with this question during our discussion, but maybe if you can just clarify insofar as President Jacob Zuma's benefits as a former head of state, should he have made it to parliament, how was this situation going to be dealt with?
Yes, it's as I said before, it's a simple thing that he'd have to make a choice. He can't have both. And the more beneficial choice would be to retain his presidential pension, because it pays more than the MP salary. But, Mr. Zuma is a humble man, and so maybe he would have said, I won't take a dime. He'd be like Bloomberg, the mayor of New York, who said, I'll take $1. That would be up to him as well if he wanted to, I suppose.
Right. And before the caller, you basically was trying to make a point. Do you still have the point?
One thing I thought that would be interesting to address, Henry made reference to South Africa having more of an inquisitorial system than an adversarial system.
Yes.
And there is something in that. So we generally describe ourselves as adversarial, in that judges must be constrained to the facts before them, and to the questions that are asked, before the court, and to the relief sought by the parties. But we do have a couple of sort of special tribunals that stray from this. So equality courts, for example, are seen as sui generis in that they have their own mandate, and their inquisitorial approach is more common. And so judges might call for certain kinds of evidence, or ask the parties, whether it's more appropriate to have different relief from that which they asked. But generally, I think it is quite important that judges don't descend into the arena, because, as you say, they can be accused of acting for political reasons. And that's really, most judges act rather like an umpire, in that they say, well, given what's before me and given how these cases have been pleaded, I would decide this. And sometimes they might allude to say, if other evidence had been led, or if this was available to me, I could have decided otherwise, but it wasn't, so I'm not going to. We do have a thing called judicial notice, so judges can take into account some limited other facts that everybody else knows. So in other words, it's not strictly before them in the papers or on the oral evidence that was led in trial, but everybody knows that February has 28 days, barring leap year when it's 29, so you don't need to put that in. And there's other kinds of things they could take into account too.
Yes. Thank you so much. I know you, Mr. Henry, you would want to make a comment, and especially to speak about the issue around the immunity of sitting or former presidents in Namibia. But let's hear from a caller from Arandes. Good evening. Good evening, sir.
Good evening.
Yes.
This is Gambara from Arandes.
Thank you. Go right ahead, and you will be our last caller for this evening.
Okay. Thank you for the opportunity. I'm saying, us as in the Namibian context, we are like. Can you hear me?
Yes, you just speak a little bit louder because we are a little bit struggling to hear you.
Do you hear?
Yes, let's try.
Okay. I'm saying, in the context that we have now, we have so many denial. We deny the realities that are there. Everything that is happening in South Africa, it's so come to us. Even the perspective of COVID-19, we were having 35, and then later we had spiraling cases. Something that we have to understand is the reality is South Africa and us, we are like so complex in reality. So I'm just careful to say that we have to prepare for a change that is coming in our nation. And I've listened to all the legal aspects of the presentations that we had together. I'm very informed and I'm grateful, but we have to prepare for what is coming in Namibia.
All right. Thank you, sir.
Thank you, sir.
All right. Mr. Shimtukeni, that was more of a comment than
I think just to add to his comment, look, it's fine. You must remember that both constitutional frameworks of both countries were created particularly to deal with those particular situations. They didn't envision anybody governing till Jesus comes or till Jesus doesn't come. What if he doesn't come? Our methodology, our laws, like you asked in the beginning, what is our frameworks?
Yes.
Cater for that. I don't think there's anything to be worried about. And the state should continue to function. That's what the constitutions provide for.
Yes. Immunity.
Immunity. Look, it's quite, I think in hindsight, our Namibian constitution is very clear. Very clear. I think it's 31 article, somewhere there. But it provides for immunity against a sitting head of state for anything that he does in his personal capacity may not be sued during that particular period while he's president, anything committed during that period. But I always look at South Africa and they are very silent, and they are silent. And I'm happy that they are silent on it because when I look at the practical in terms of what happens, imagine had there been immunity. We have immunity here, but we really, I don't know, for some reason, we really haven't had many issues. But looking at the issues that happen in South Africa, I sometimes think I'm glad that their constitution is silent on it. Because
it provides for a general or broader way of...
Ordinarily, they say that you don't give immunity because you are guarding against autocracy. You're guarding against autocracy. Yes. So in hindsight, I say it's a good thing they don't have it expressly like ours. Ours is very clear. Even after, you can't be institute proceedings, both civil and criminal, for things committed during that particular period. South Africa's is silent, that's why he mentions, those kind of things. But our Namibian constitution is very clear and explicit. I think it's very odd because the same drafters of our constitution, some of them were from South Africa. Well, the ones who contributed to the draft. I really don't know why they didn't include it. Perhaps we shouldn't have. I don't know. But the principle around not including it is to guard against autocracy.
Yes.
But I'm also happy that South Africa didn't include it because our big brother is,
Let's get back to the issue of terms of office and how often an individual is allowed to basically...
We had one amendment.
Yes.
The only amendment we had which allowed for someone to serve more was the one that was created for Sam Nujoma, and the interpretation of the rationale. Remember that there's obviously the amendment to the Constitution, and then we also study what was the rationale behind it. The rationale apparently was that the first term in 1990 was the term, the UNTAG term, and then because remember that when we interpret law, interpreted based on what was the rationale behind the amendment. So it gave him beyond that. is only the 10 years. He's the only one. He served 15 years, remember?
Yes.
He served from 1990, then he came from there. So that's it. That's the limit, and that's it.
Yes,
Yeah.
but let's say a head of state served only for one term under the auspices of a certain political party. Can he then serve a second term as an independent candidate or under the auspices of a different political party?
From interpretation, we've never seen it, but if it says 2 terms and you've served one, I don't see why you can't serve another. You get it?
Yes.
Yeah, look, just the interpretation. If it says 2 terms, you've served
or
one.
be it maybe as an independent presidential
Doesn't
candidate.
matter. Look, independent candidate or not. Ne?
Yes.
That is again. I like using the word administrative. When
Yes.
we were here with the gentleman from ECN,
Yes.
that's purely based on how you're nominated by a party or yourself. It says 2 terms. It says 2 terms of 5 years. If you've only served one, I don't see why you can't serve another. You get it? So whether it's independent or through a party, I don't see the inhibition. We haven't seen it practically. I don't know. I would like to hear from advocate in terms of South Africa what their interpretation would be. Had it been that Zuma had served his full, well, he didn't serve the last term full, but you can
Yes.
say he served 2 terms.
Yes.
What would he have been able to be president again? I'm not sure. Let's hear from advocate.
Advocate, let's hear from Johannesburg.
Yes, it's an excellent question. So our constitution is quite explicit that you can only serve 2 terms, and then it says what doesn't count as a term. So it says that if a president vacates their office and someone else stands in their stead, like Kgalema Motlanthe and Cyril Ramaphosa, that doesn't count towards a term. So it is actually possible to be president for more than 10 years under South African law because that period isn't added to the 2 terms. So Cyril Ramaphosa did his interim term. He then did 5 years, and it's possible that he'll be elected for a further 5. It would make him, I think, the longest standing president in modern South Africa's history, because no South African president has ever stood full 2 terms. Nelson Mandela served 1 term, Thabo Mbeki resigned, Jacob Zuma resigned. So it would be unprecedented, but the law caters for it. It wouldn't matter which political party, by the way.
Thank you so much. When we return, we'll take a look at our customary jargon of the day. Welcome back. We now take a look at the jargon of the day. Perhaps let's start with you, Mr. Shimtwikeni. Explain what government of national unity is.
Again, I emphasize and I say, to be honest, the ANC is being very mischievous, and advocate knows. That is a word which comes from a particular regulated framework. And it's a 1993 word which comes from that particular era, where a government was formed to include everyone, a cabinet of 27 people, including the National Party, IFP, based on the amount of seats that they got. People are throwing it around now. I really don't know its applicability.
But in a nutshell, it is supposed to be a government which includes...
It was created at the time to unite post-apartheid South Africa. That was the discussion. So the ANC is creating a crisis as if they're at the same juncture, which they are not. They just lost elections.
Thank you so much. Advocate Oppenheimer, can you just explain in simple terms what a coalition is?
I think would be that you formally join forces in the executive. So in other words, those parties that partake in the PR stunt of government of national unity could be in a coalition together in that various cabinet positions are divided up.
Right.
As I say, there is another alternative, which is the confidence and supply arrangement, where you don't actually have a coalition, but you have cooperation.
Right.
So there it could be the case that those parties don't take up posts, but they agree to support Cyril Ramaphosa as president and agree to pass budgets.
Yes, and on
So
that
that's been
note,
described as a no-elition.
yes, and advocate, thank you so much for making time again to share your expertise with us here on the Wheels of Justice. But anything, any final submission that you would want to make?
Yes, well, I have to say it's been absolutely wonderful to be on your show, partly to see South Africa viewed from our neighbours' eyes. I think in South Africa we've felt an enormous amount of tension since our election results, and a lot of tension before. And what has been so remarkable to me about this conversation is how knowledgeable and calm both of you are. And I wish you luck for your forthcoming elections.
Yes. Mr. Shimtukeni, any final remarks before I hit the gavel on the block?
Look, I think we need to learn. Our constitutions are similar. Our systems are slightly different. We need to learn. We've been able to transition from the passing of a president to another, and the change of a political party in terms of governance should not affect the functioning of the state. And we need to learn from our big brother South Africa, and I think we will be fine. I think it's important to learn, watch and learn.
Right.
Yeah.
Thank you so much. With that, we've come to the end of this week's episode of The Wheels of Justice. I am Daniel Nadunya, and this session stands adjourned.